To another question, your petitioners, do they have an interest in the matter, or they've come purely as a matter of public interest?
No, I am looking at section 3.
No, I'm not talking that. I'm not asking a question of the petitioners. Do they have an interest in any case why they brought this challenge, or they brought it in the public interest? What is the answer?
Answer to that is that it's a public interest.
You have no personal interest in the matter, you or your client.
I have no personal interest.
You meaning your client.
But let me say this thing.
I just want to know an answer to that.
Myself and Mr. Siddiqui, we are doing this as pro bono. We are doing it because we want to know, we want to see.
I don't know who you're speaking for. Are you speaking for counsel? Are you speaking for petitioners?
I'm speaking for the petitioner, and I'm saying this thing that we brought this petition
in the
interest.
You got the answer. Now please proceed. I've got the answer.
You got in the interest that the law should take its course. The constitution must be upheld. And I'm also saying that I'm sure with such preliminary sitting there, of the whole object is that first of all, the independence of the judiciary should not be in any manner smeared by any other institution. And secondly,
please.
We are not going to platitudes. I will not make a political speech.
So,
I'll refrain from that.
Just proceed with that.
Yes, sir.
Khwaja Sahab, just a confusion which you can answer later. So what you are saying is that the untrammeled, unaccountable powers of the Chief Justice exclusively to decide constitution of benches, you were satisfied with that, and that fulfilled the conditions of Article 10A. But if it is done by the Chief Justice and two senior judges, you have an objection to that. That's your proposition.
I think your Lordship is possibly not. I've not been able to explain. Section 2 stands on its own footing, and I have objection on that. Section 3 is a totally different thing. It takes away the powers of this honorable court. Instead of
let us clarify.
Is it your argument that Section 3 affects the judicial powers of this court?
Yes, ma'am.
Curtails judicial powers of this court, because this court means the Chief Justice and all judges. So it confines that power to 3 judges and not to the judges of the Supreme Court.
That's what mine. 2 and 3 have to be read independently and separate.
Now, please.
There are 2 in exercise of administrative powers.
Yes, ma'am.
I'm trying to make your life easy, but if you don't want it to be made easy, that's fine by me. Please don't interrupt. I've requested you, please keep noting the queries. Naturally, you have a chain of thought, you have submissions. We don't want you to get, I can appreciate your position. So many judges, so many questions, which one do you answer? And then your argument is lost sight of and you go somewhere else. So please persevere with your thing, keep noting the questions, and you can address them. So I'm trying to make your life easy, unless you don't want it to be made easy. So proceed with your case. Note the question, respond to it later.
To be very honest, I welcome this interruption.
Can I ask you a question? Can I ask?
Far right.
Please. What about the office of the Chief Justice after passing of this act? Don't you think that the office of the Chief Justice would become redundant? Because he would be left with no powers then.
We noted this down, and in fact, I would say that the Chief Justice powers will be whittled down, as if this law goes through, the powers will be whittled down, but we'll explain it. And this has been held in many places, that the Chief Justice has the power to form the benches, is the rooster, and I can go back years and years when a chain of judgments have come in, and the latest one is, of course, 2000. I will continue. Let me continue.
Note कर लें, बाद में कर लें.
Let me continue.
Mr. Khwaja, I will add it.
Then is a question.
Mr. Khwaja.
Yes.
Right side.
Right side. Okay.
I will add to it. Whether the power of the Supreme Court has been curtailed or the power of the Chief Justice.
I
This
think
is the moot question.
the answer to that is that it's noted, sir. It's noted, and I will only say this thing that Supreme Court. What is Supreme Court? Supreme Court is the Chief Justice and so many other judges.
Faez sir, we'll be sitting here till 12 o'clock.
I know that, sir.
So आप जरा
let's
अपना
go.
argument करें. अभी तो हम section
Let's
3 पे पहुंचे.
let me on section 3. I will only say this thing that this certainly is the Parliament has taken away the power not only from the Supreme Court and the judges, but also it has condemned me unheard and violated the provisions of Article 10A, which provides for a fair trial. Because I will file a petition. I've not even heard, and 3 judges or about 2 judges, they will decide on an administrative side, and I'll be out. So the question of 184.3 will become totally redundant. This is my point. Therefore, to that extent, section 3 is present. Then next is 4. Interpretation of the Constitution. In the matters where interpretation of the constitutional provision is involved, committee shall constitute a bench comprising not less than 5 judges of the Supreme Court. I will.
Do you object? First say, I object to this provision, or you endorse it?
I will say this, sir, that in the matters of interpretation of the Constitution, when you are, all the judges are competent to interpret the Constitution. By limiting it to 5 or limiting it to 3 or why not 7, why not 6?
Please.
I object to this thing that this is a limitation.
No, it's not a limitation. It says not less than. It could be a full court like the present court. So are you just safe? Is this ultra vires the Constitution, Section 4? Say something. We should know.
On this, I will only say this thing that putting a clause that the bench should be not less than 5. That possibly is expressing, shall I say, not confidence in less than 5 judges.
Noted.
Because this is very strange. Because all judges are equal. Your Lordship is the first amongst the equal, but every other judge of the Supreme Court has the same powers and the same acumen. So by saying this thing, not less than 5. Then there's a question of appeal, and which is a very relevant point.
Ajay Sahab, as I understand your earlier proposition, you are satisfied that the Chief Justice in the previous model, being the master of the roster, had untrammeled power to constitute a bench of 3 members, and you were satisfied with that.
I have noted this thing.
Yes.
Your Lordship did not. I would not be able to explain. It's my shortcoming.
Explain later.
On the question of benches, I have stated with this thing that this power should be exercised by the full court, not by the Parliament. How the benches are to be. I will dwell on that.
In a nutshell, you are suggesting that the powers as master of the roster in the Chief Justice were also unconstitutional.
No, sir. No, sir. I'm saying this thing that under the 1980 rules, that power had been given. If all of you sitting together feel that under 191 that this should be changed, then it is your functions. It is not the function of the Parliament.
Okay, now let's proceed. We'll ask.
I'll do on that. That is the point which needs consideration. 5 is appeal. Yes, Manisha.
On section 4.
On 4.
If memory serves me right, section 4, what is the equivalent of section 4, is part of the Indian Constitution as an article of that Constitution. It was a part of the 1956 Constitution as an article of that Constitution. Now, question is that when the framers of the present Constitution had before them this model where this very power was conferred on the Supreme Court in the way that what in India they are called constitution benches, the question is this: that model, that aspect was not accepted by the framers of the present Constitution. because they had a model both from India and from Pakistan itself. So the question is this: if that was not accepted, does this not require constitutional amendment? Can Parliament do something which the framers of the Constitution deliberately seem to have left out, despite the earlier models? Can Parliament then, in exercise of sub-constitutional jurisdiction, namely legislative competence, do something that was earlier part of the Constitution? This is the question. Please note.
Yeah, it's noted, sir, and I may add on to this.
साहब मैं एक सवाल पूछ लूं आपसे, अगर उसी में डाल दें आप लिस्ट में अपनी।
जी
मैं इधर हूँ जी।
जी सर।
भाई बस सिर्फ सिंपल सा आपकी जो समझ आई है मुझे आपकी कि ये सारा कानून अगर यही सारा फुल कोर्ट बैठ के बना ले तो सब ठीक है।
नहीं सर,
सुनिए ये सवाल तो सुन लें।
जी जी।
कि 17 जज बैठ के ये सब कुछ बना ले तो ठीक है, पार्लियामेंट ये सारी चीज बना दे तो गलत है। ये आपकी बहस है ना सारी?
नहीं सर, ऐसे नहीं है।
आपने यही कहा, आपने कहा ये सारी चीजें करो, लेकिन
नहीं सर ऐसे नहीं,
सुप्रीम कोर्ट का
नहीं सर ऐसे नहीं है।
चलिए बस नोट कर लीजिए।
मैं नोट कर लिए कि जब सुप्रीम कोर्ट
आप जवाब ना दीजिए ना, बाद में
मैं बाद में जवाब देता हूं,
ठीक है? अदरवाइज तो आप आपकी मुश्किल काम हो जाएगा।
मैं आई एम क्वाइट I have a very
नहीं, आगे बढ़ते हैं।
I have worked with all of you, sir.
आगे बढ़िए।
I have no problems.
हजूर आगे बढ़िए, आगे बढ़िए।
मुझे कोई problem नहीं है. I understand what Shah Sahab is suggesting and saying, and he has mentioned this in many other cases. Yes, ma'am.
If I may ask a question as a supplemental to the question that my learned brother, my learned colleague has asked. Independence of the judiciary is a recognized fundamental right.
Yes, ma'am.
So the question, surely, this is the question to you. Surely, the question of what the court can itself do to regulate its own practice and procedure is now encased in independence of the judiciary, and can Parliament intrude upon, with all due respect to Parliament, they have their legislative competence, the Constitution is supreme, that is what is paramount, that is what is there. Can Parliament, in professed exercise of a legislative competence under Article 191, trample upon, I'm using this word a bit deliberately, I don't intend to show any disrespect to Parliament, but can it encroach upon or intrude upon something that would affect the independence of the judiciary, something that relates to practice and procedure, which the court may or may not do, but can do for itself? Can Parliament do that? In other words, when Article 191, this is part of that question, starts with subject to the Constitution, the law part of it is also being subject to the Constitution, and the Constitution says independence of judiciary is a fundamental right. Can Parliament directly or indirectly take away a fundamental right?
Not through ordinary legislation.
आप नोट कर लें, जवाब ना दें।
Not through ordinary legislation.
If I will really request my colleagues that they are making, including myself, are making your life impossible. No, please, no, you are very fine.
I'm learning.
No, we are not here to teach you anything. You are here to help us. Now, please, we're not even reading the act, and we are getting bogged down into details. Let us go through it, formulate your contentions. We will bombard you with 100 questions. You respond to them later. You respond to everything, then the matter gets lost. Again, we are stuck with section. We are not even making progress. Please continue in your way.
आगे बढ़ते हैं. Let me say this.
Mr. Khwaja,
Khwaja sahab, section 5 से आगे पढ़ लीजिए.
Another question with regard to appeal. आप देखें, हमारे पास already एक dictator का ordinance था, Law Reform Ordinance 1972. उसके तहत Article 199 के लिए appeal provide की गई before 2 member benches. We are following it. क्या वो जो डिक्टेटर का था वो दुरुस्त है और पार्लियामेंट अपील का राइट नहीं दे सकती? वहाँ तो अपील का राइट दिया, सेम प्रोविजन कॉन्स्टिट्यूशन, आर्टिकल 199 हियर आर्टिकल 183 84(3). तो ये क्या दोनों में
Sir, it is
गलत है तो फिर वो भी गलत है?
It is noted. We'll answer this thing, that what Parliament can do and what Parliament can do many things. My Lord has said so, but there is a procedure provided. We'll answer that.
भाई साहब, अभी जो आपकी जरूरत नहीं है, आप
I will not answer it.
पहले एक्ट को खत्म कर
Section
लीजिए,
5 से आप
फिर हम
आगे
आगे
बढ़
चलते
लीजिए,
हैं।
ख्वाजा साहब.
Khwaja Sahab,
You have collected 100 questions.
Just here. The Law Reforms Ordinance of
I don't think how you will
1972,
answer.
this is the question to you, regulated right of appeal
101.
within the High Court itself, an intra-court appeal. Was there ever a clog on the jurisdiction and on the legislative competence in relation to jurisdiction and powers of the High Court in the same manner as it is in the Supreme Court? As I read it, the clog is there only in respect of the Supreme Court. Law Reforms Ordinance didn't do anything with the Supreme Court. It only affected intra-court appeals within the High Court, both in the concurrent, which is now no longer there, and also the clog was only in relation to Supreme Court. Question: is therefore the Law Reforms Ordinance of 1972 a parallel valid example which relates only to the High Courts, a valid parallel example in relation to what Parliament seeks now to do in the 2023 Act? This is the question. With relation to the Supreme Court, where there is apparently a clog.
Mr. Noted, sir. And appreciate. Section 5. An appeal shall lie within 30 days from an order of a bench exercising jurisdiction under Clause 3 of Article 184 of the Constitution to a larger bench of the Supreme Court, and such appeal shall, within a period not exceeding 14 days, be fixed for hearing. And second part, the right of appeal under subsection 1 shall also be available to an aggrieved person against whom an order has been made under Clause 3 of Article 184 of the Constitution prior to the commencement of this Act, provided that the appeal under this subsection shall be filed within 30 days of the commencement of this Act. I'm not going to analyze it. I have my serious objection on this, and I will.
What you have to do, you're not going to do it.
My
Well, you have challenged the law, you have
my
to do,
lord,
you have to challenge it.
Appeal shall lie within 30 days.
We've read the English of it. What's wrong with it? Tell us that.
My lord, as far as Section 5 is concerned,
Is it good? Is it bad? First, tell us that.
Well, it says that appeal shall lie within 30 days from an order of a bench exercising jurisdiction under Clause 3 of 184. May I respectfully submit that if an appeal is provided against a decision under 184.3, then why is this not they included in Clause 2? Whereby my 184.3 application will be disposed of.
The way I was taught law was not the council asked questions from the bench. It was the bench would ask questions. Are you supporting this provision or not? First say, yes, I am. No, I am not. These are my reasons.
My lord, I have a reservation on this.
You may have reservations. Tell us what's unconstitutional about it.
Then let me explain it to them, because if I start explaining it as it will take your time. But I will say this thing, that this Section 5 should have also, this right of appeal should also have been given in Section 2.
Should is different from ultra vires of constitution.
It ought to have been given.
What then? You go and move a bill in Parliament. We are saying, are you opposed to Section 5? Give us legal reasonings, or you say it's okay. अब उनसे आप पूछेंगे.
You have done this.
नहीं ये नहीं आप जवाब दीजिए ना. आपने petition लाए. This is not fair.
Don't want your client to have a right of appeal.
No, sir, I.
First say it's unconstitutional, it's constitutional. You're not saying anything, you just. यहाँ कोई discussion होता है, sorry, not on. This is your job in office.
My lord, may I say this thing that we divided the.
Please answer the question, is this constitutional or unconstitutional?
It is unconstitutional.
I can't hear you.
इसकी वायरिस तो बताइए ना, वायरिस क्या है?
Hey, unconstitutional आपके जहन में और नहीं है.
Unconstitutional.
Well, it's my personal opinion is this, sir, that this Section 5 goes beyond the powers which were there with the Parliament.
The
So
Now
ultra virus
formulate a contention on that. Please formulate a
for
contention.
the simple reason, my lord, if an appeal is to be provided, it's a substantive right. There has to be a constitutional amendment. An ordinary law cannot provide.
I
this
can't
kind of-
seem to reconcile your, which I appear to me to be contradictory submissions.
No, I'm simply saying
Please
that-
let me finish.
that this-
Please let me finish.
Yes, ma'am.
On the one hand, you are saying, where will I go? Where will I go? Here, the parliament has given you a right. You say it's unconstitutional. So please don't make contradictory contentions.
I'm only saying this thing, that it's a good thing that the right of appeal will give, but the manner in which it has been given
Man,
is
take it,
wrong.
please take it.
I'm saying this thing, that this one, the right of appeal given in this manner by an ordinary law.
We will
is
not strike it down because of manner. You have to show us ultra vires the
It is
constitution.
unconstitutional, sir.
But saying so, no argument.
Our argument is this, that 184(3) is to be given, there has to be a constitutional amendment.
Okay, point taken. Move ahead.
ठीक है जी? ये बात नहीं पाई।
I just have a question to you with regard to Section 5 from what you have just said. Kindly read it again.
An appeal shall lie within 30 days from an order of a bench exercising jurisdiction under Clause 3 of Article 184 of the Constitution.
Just kindly stop. So this order, the question to you is, has two parts. The first part is, this question, this order, which is now made appealable, is it a judicial order or is it administrative type of order? And if it is a judicial order, then how can Parliament, in exercise of a legislative competence conferred by Article 191 in relation to practice and procedure, confer a right of appeal? Because, if I may, and this is the, I apologize, my question has three parts. Because if I may touch upon what my learned colleague, Mr. Justice Mansoor Ali Shah, said recently, that this is recently, meaning in the hearing of the case, that anything that this law does, the Supreme Court can itself do in exercise of rule-making power. Question therefore is, can Supreme Court confer a right of appeal in exercise of rule-making power against a judicial order under 184(3)? If the answer is no, then it seems to me logically that Parliament also can't do it because the two things are parallel. Therefore, question, is it therefore unconstitutional?
Unconstitutional.
You don't
This
have
is
to
my
give an,
point.
you don't have to give an answer. Just note it down.
If the right of appeal had to be
आगे
given,
बढ़ें,
it
आगे
should have been
बढ़िए,
given
आगे।
through an amendment.
So note it down.
Yes, next is right to appoint.
आप चाहें आप हमें लिखकर तहरीरी तौर पे भी जवाब दे दीजिएगा, ठीक है? अगर आप आगे अपना आर्ग्यूमेंट चलाते रहें, जी, आगे बढ़ते हैं। सिक्स 6 को पढ़िए, 6 को।
6 है जी, right to appoint counsel of choice for filing a review application under Article 188 of the Constitution. A party shall have the right to appoint counsel of its choice. I don't object. I personally don't object.
पर्सनली की बात कोई नहीं है आपके।
I'm not objecting to this because I feel that.
Okay, it's okay. चलिए, let's get on with it. Section 6 is okay.
Okay.
Application for fixation of urgent matters, application pleading urgency or seeking interim relief filed in a cause, appeal or matter shall be fixed for it. My objection on this is again that this is a function of the Supreme Court itself, because this relates to the
Please
procedure.
tell us, is it ultra vires a constitution?
It's ultra vires.
Thank you.
I just have a question to you on this, on Section 7. Now, Section 7 really relates to what is regarded as the nitty-gritty of procedural law. I mean, this is really going, say, in a civil court, into the very depths of CPC, or the way we in the Sindh High Court have original side into the Sindh Chief Court rules original side. The question, therefore, is this. The legislative competence under Article 191, if it allows Parliament to go into so much depth into the very nitty-gritty of procedure of the court, then surely Parliament has an untrammeled power to regulate the court itself. The power to regulate, if I may adapt is the power to destroy. Does this not effectively destroy the independence of the judiciary?
This was my very first point which I
Faez
said,
sir,
that the functions of the
is
Supreme
it-
Court have been virtually been taken over.
Is this not contrary to the fundamental principle of the Constitution, trichotomy of powers? So where the legislative organ is intruding upon the nitty-gritty and the procedural aspects which have specifically been left to the Supreme Court under Article 191, is it not an intrusion in the boundaries created by the trichotomy of powers?
That is why I say 7 is ultra-vires.
इसमें ख्वाजा साहब, I think there's a very crucial and important question. The jurisprudence of this court, developed till today, has only looked at one aspect of independence of judiciary, that is freedom from external factors. But there are two other extremely or probably more important factors that affect independence of judiciary, and that is internal independence and institutional independence. What the Parliament appears to be looking at is the aspect of internal and institutional independence, where probably in the perception of
Just note kar.
the public or the Parliament, those powers exercised over the years by the Chief Justice under the rules, they actually eroded the internal and institutional independence. So, when we talk about independence of judiciary, these two aspects that have been ignored till today, they are probably more important.
That will certainly answer your lordship.
So, but please, one question also.
Since we have just
Raja
one
Sahab.
section, can we just finish reading it?
Sir, if I may have a supplemental on
Yes,
what
ma'am.
my
Please,
learned
please.
colleague has said. Is it possible, is it constitutionally possible that if at all, and speaking for myself and with very great respect, perhaps I do not subscribe to that view that has been expressed, but I ask a supplemental question on it. Is it constitutionally conceivable that if there is such a concern about the internal independence
working
of
of
the
the power.
judiciary, that the solution is to put the power in the hands of Parliament? Would
That
that
will-
not violate separation of powers?
Yeah, it will-
Tomorrow, what is there to prevent, and this is a question to you, what is there to prevent Parliament from making a so-called law relating to practice and procedure and provide the federal government is hereby conferred powers to make rules and, for the practice and procedure of the court? There is no end to it. Is if at all there is any trouble, and I, as I say, I have very deep regard and respect for my learned colleague, all of them, but in particular Justice Athar, is this really the solution? That you say, okay, here's a problem internally to the, would that not violate? Well, I mean, no, as I say, it's constitutional. Is it even conceivable? I mean,
With
where would
Sahab,
that
एक
lead
second,
us?
Faez sahab, एक,
with due respect, my
This is a
lord,
question
to my,
to you.
my lord, this is
ख्वाजा साहब, ये एक बात सुनिएगा, इधर एक
आप
क्वेश्चन.
इसको
ख्वाजा
खत्म तो
साहब,
कर लेना सेक्शन को. आप सॉरी टू से
आर्टिकल 8 खत्म कर लो.
आप पढ़ ही नहीं रहे हैं.
मैं पढ़ने का अभी पढ़ लेता हूँ सर. ये सवाल बड़े पर्टिनेंट
आप हर चीज आप नोट कर लेना.
नोट कर भी दिया मैंने सर. कर ये कहा मैं बता, मैंने शुरू में ये कहा था.
आप शुरू में क्या कह रहे हैं? आप
मैंने
आखिरी
शुरू में-
सेक्शन पढ़
सर,
लें.
मैंने शुरू में ये कहा था, आपने शायद इस्लाम और जो ये आप कह रहे हैं कि जो इंटरनल वर्किंग ऑफ द सुप्रीम कोर्ट है उसमें किसी और का दखल नहीं होना चाहिए.
देखिए,
ये
सेक्शन 8
अगर
पढ़
ये
लीजिए आप पहले.
दखल अंदाजी होगी
जी,
तो
जी.
फिर ये सुप्रीम कोर्ट नहीं रहेगा.
एक बात और नोट कर लीजिएगा, आपने कहा सेक्शन 5 जो अपील है वो अल्ट्रा वायरस है टू द कॉन्स्टिट्यूशन, मगर एट द सेम टाइम व्हाइल यू आर रीडिंग सेक्शन 6 it is right of review. You say that you have no objection to it. Why? Because the choice has been given to appoint the council of his own choice. No, when the law is totally ultra virus,
Sir, noted.
then how you can say that section 6 is okay with you?
No, my own view was that at times we have the rules are there that if a lawyer says that I'm ill or I'm not out of the country or I'm not well, you do allow in review.
You are declaring
alert
right
also.
of appeal ultra virus and right of review intra virus.
No, Madam, what I'm saying
Yes,
is that,
according to your own
that
arguments.
the question is that you cannot provide a right of appeal.
But you can
under
provide the right of
wait a
review.
minute, sir, under 184.3. If 184.3 right of appeal is given in accordance
आप
with
मेरे ख्याल में
with the constitution, then as far
ख्वाहिर साहब फिर आप अपने लिए
Okay, sir,
आप जरा सुन तो लीजिए ना
we'll
आप ये सवाल
Okay,
जो
sir,
है जरा
we'll
सुन
answer that
आप सुन तो लीजिए ना
well, सुन लीजिए।
ये जो सवाल है इनको इतने इजीली ब्रश असाइड ना कीजिए
नहीं, मैं नहीं करता।
जरा सुनिए प्लीज आप गौर और फिक्र से हम नहीं चाहते हैं कि आप फिल बदी कोई जवाब दे दें जो फिर आपके लिए मुश्किल हो हम इसीलिए आपको हर सवाल नोट कर लीजिए आराम से जवाब दे दीजिए आप खुद अपने लिए मुश्किलात खड़ी कर रहे हैं हर सवाल के जवाब देने लगते हैं हम तो सिर्फ आपसे सवाल पूछिए नोट कर लीजिएगा आगे चल करके ठीक है हम देखें हम एक दूसरे से बहस करने के लिए नहीं बैठे हैं हम आपके सुनने का आपने चैलेंज किया है एक कानून को कि ये गैर आईनी है ये बहुत फर्क होता है कि एक कहने के लिए कि मुझे ये कानून पसंद नहीं है जरा आप प्लीज ना खामोश रहिए 2 मिनट हम भी आपको सुन लेते हैं खामोशी से आप भी थोड़ा सा तहम्मुल का इजहार कर लें तो ये बहुत से कानून है शायद मुझे भी नहीं ज़ाती तौर पे पसंद हो ठीक है मगर मैंने हल्फ उठाया है कि मैं आइन और कानून पे अमल करूंगा ताकि अनलेस कि मैं उसको स्ट्राइक डाउन कर लूं कानून को वो एक अलग बात है कि ये अल्ट्रा वायरीज द कॉन्स्टिट्यूशन है तो आपने कहा माय पर्सनल ओपिनियन डजंट मैटर तो आपकी भी पर्सनल ओपिनियन की कोई हैसियत नहीं है आपको आईनी जवाब हर चीज का देना है कि ये इश्क आपने एक बहस में एक आर्टिकल आइन का आपने रेफर नहीं किया कि ये किस आर्टिकल के तसादुम में है दूसरी बात आपने जो बिल्कुल नजरअंदाज कर रखी है ये हमने स्यूमोटो केस नहीं लिया अगर हमारे हकूक पे इतना जबरदस्त वार पार्लियामेंट ने किया होता तो हमने बहुत सारे केसेस में हमने खुद भी उठा लिए केसेस को ये तो आप हमारे तरह से वो डिफेंडर के तौर पे रूनुमा हुए हैं और कहा ये जंग मेरी है ठीक है ये सिर्फ प्रोसीजर मैटर है किसमें किसी की राइट गायब नहीं हो रही किसी की राइट एक राइट कन्फर हो रही है किसी की राइट छीनी नहीं जा रही है तो बराए करम आर्टिकल 184(3) के दायरे में रहकर आपने जिसका आपने एक लफ्ज नहीं जिक्र किया है वो कहता है एनी मैटर ऑफ पब्लिक इंपॉर्टेंस चलें जी पब्लिक इंपॉर्टेंस तो एक वो है डिबेटेबल क्वेश्चन आप हम ये कहूँगा आप कहेंगे वो है मगर फॉर द इन्फोर्समेंट ऑफ फंडामेंटल राइट्स ठीक है ये इसके प्रीएम्बल में उन्होंने फंडामेंटल राइट्स का तस्करा कर दिया है जिसको आपने बस नजरअंदाज कर दिया ठीक है ये बहुत अच्छी बात है कि आप मेरे हकूक के लिए जंग लड़ रहे हैं मगर ये मेरे हकूक और आपके हकूक की नहीं बात है ये आइन की बात है और लोगों के हकूक की बात है ये आर्टिकल 10(a) का हवाला देता है आर्टिकल 25 का देता है तो आप खड़े होकर अपनी राय आप कॉलम लिखिए अखबार में हमें सिर्फ और सिर्फ आइनी बहस कीजिए कि ये 184(3) का जो हम जो पावर आज इस्तेमाल कर रहे हैं वो 100 ये हम अपेलेट पावर नहीं इस्तेमाल कर रहे हैं ना कोई हाई कोर्ट ने कोई फैसला किया है जो हम बैठे हुए हैं एज ऑफ राइट अपील सुन रहे हैं पिटीशन फॉर लीव टू अपील सुन रहे हैं हम ओरिजिनल जुरिसडिक्शन में बैठ गए उसकी बहुत महदूद चीज़ें मुझे बहुत सी चीज़ें कानून में शायद ना पसंद हो मैं ये नहीं कह सकता हूँ कि जी इसको ऐसा कर लें कि ऐसा नहीं करना चाहिए था तो आप बराए करम आपने एक इन्फोर्समेंट ऑफ फंडामेंटल राइट से तो आपने कुछ बहस ही नहीं की अभी जरा आप प्लीज और हर बात को आप नोट कीजिए अगर आप तो बस आप हर चीज को जवाब देने लगते हैं बगैर सोचिए हर बात की बहुत अहमियत होती है मेरे कोलीग की जो सवाल हैं वो बड़े अच्छे सवाल हैं जरा गौर और फिक्र चाहते हैं और फिर जवाब देते हैं अगर आप जल्दी से करेंगे फिर आपको दोबारा मौका नहीं देंगे फिर कहेंगे अब मुझे अच्छा जवाब आ गया फिर अब आप प्लीज 184(3) के तकाजे भी पूरे कर लें
आपके बिल्कुल 184(3) के तकाजे
मेरा एक सवाल भी नोट कीजिए केपी ऑन द बॉर्डर प्लीज आप क्या सोचते हैं एक्ट हैज बीन पास्ड इन द पब्लिक इंटरेस्ट क्योंकि सेक्शन 5 सबसेक्शन 2 says on the contrary it appears that to do away with some of the decisions which were passed in the previous years under Article 184(3) of the Constitution, क्योंकि commencement उनकी कर दी है और इसमें कोई limitation भी नहीं है. तो ये public interest में pass हुए या personal interest में हुए?
Yes, your point is noted, sir. I will not answer now. I'll answer it later.
Mr. Khwaja, another question.
Sure.
Please एक और note कर लें. We have two provisions in the Constitution. One is Article 191, which relates to Supreme Court, and the other is 202 of the Constitution, which relates to High Court. Same अल्फाज है वहाँ से वहाँ पे Supreme Court, यहाँ पे High Court. Subject to the Constitution and law. Law तो बनाती है Parliament. तो आपके आर्गुमेंट से हम ये समझें कि पार्लियामेंट को आप लॉ मेकिंग में महदूद करना चाहते हैं कि आप ये तो कर सकते हैं, ये नहीं कर सकते, ये रूल्स में सुप्रीम कोर्ट खुद करेगी या हाई कोर्ट खुद करेगी.
सर मैं इसका आंसर दूंगा, बिल्कुल दूंगा, क्योंकि जब सब्जेक्ट टू कॉन्स्टिट्यूशन आ जाएगा और जो लॉ आएगा वो आपको कॉन्स्टिट्यूशन के साथ देखना पड़ेगा.
ये भी कि क्या लॉ के तहत क्या कर सकते हैं पार्लियामेंट, क्या नहीं कर सकते.
क्या नहीं कर सकते, ये इसका जवाब देंगे जी आपको. इसीलिए तो
another question, where a rule has been framed under constitutional power granted to the court.
Yes, sir.
This is with reference to section 6 that you just read. You would notice that Order 26 of the Supreme Court rules does provide for all eventualities in which a review can be filed procedurally. The question is where the Supreme Court, in exercise of constitutional powers granted by the Constitution framed rules, the Parliament can legislate and override those rules or amend those rules. That's the question. Noted. Please answer when you are answering.
Additional through already law or through the point is taken, sir, by already with me, and I will answer that. And I have my own views on this, that the Parliament cannot do this thing by an ordinary.
हुजूर आपके व्यूज को छोड़ दीजिए ना, आईनी तकाजे पूरे कर लेना.
Number 7 is application for fixation of urgent matters.
ये तो हो गया.
Application pleading urgency or seeking internal relief.
अच्छा, मैं आपको एक मफरूजा पे छोड़ देता हूँ. आपने दरखास्त दी, बहुत अहम केस है, अर्जेंट केस है, मैं नहीं लगाता हूँ. मेरी मर्जी. सिर्फ जवाब दे दीजिए, मेरी मर्जी. मैं 10 साल उस केस को नहीं लगाऊं. मेरी मर्जी.
मैंने इसमें कुछ नहीं कहा.
मैं आपसे सवाल पूछ रहा हूँ जी. इन्होंने मेरी मर्जी ले ली, शायद मैं खुश नहीं हूँ उस बात से. मेरी मर्जी में ना लगाऊं केस. एक बहुत अहम केस है, इसमें उन्होंने लिख दिया 14 दिन में आप उसका भाई सिर्फ उसको लगा दें, कोई फैसला तो ना करें. तो मैं कहूँगा मेरी मर्जी. मैं जो ये टैक्स पेयर पैसे दे रहे हैं इस अदालत को, जो हमारा बजट है, मेरी मर्जी पे चलेगा. इस पे सवाल का जवाब दीजिए. मैं नहीं लगाता हूँ. आपका ये केस आपने फाइल किया, ठीक है, मैं नहीं लगाता इसको. आप क्या कर लोगे? कुछ भी नहीं कर सकते हैं. आपके हाथ पैर कटे हुए हैं. इन्होंने हम पे भी, मेरे कोलीग ने एक बात की इंटरनल और इंस्टीट्यूशनल इंडिपेंडेंस की. मैं 2 बातों का इजाफा भी करना चाहता हूँ, और वो आइन से पहले भी हमारे पास था. वो हमें ऊपर वाले को हिसाब देना है, ठीक है. अकाउंटेबिलिटी एंड ट्रांसपेरेंसी. आप हमें टोटली अनअकाउंटेबल बनाना चाहते हैं चीफ जस्टिस को. मैं तो बहुत खुश हूँगा, क्योंकि ये कानून अगर सस्टेन हो जाता है तो मेरे पार तो कम हो गए बाकी चीज़ों को छोड़ करके, ठीक है. इस कानून को उड़ा दें, मैं ताकतवर बन जाता हूँ. ये भी है, मैं अकाउंटेबल हूँ. ये भी एक सवाल है. आपका आइन जो शुरू होता है वो सुप्रीम कोर्ट की इंडिपेंडेंस से नहीं शुरू होता है, वो अल्लाह ताला के बाबरकत नाम से शुरू होता है, ठीक है. और हम सब everyone to exercise powers as a sacred trust. आइन में आर्टिकल 227 भी दी गई है कि शरई असूलों पे अगर आपके कोई भी कानून तसादुम करे तो वो प्रिवेल करेंगे. तो बराए करम एक इंडिपेंडेंस ऑफ द जुडिशरी से ये मतलब नहीं कि अगर इंडिपेंडेंस ऑफ जुडिशरी से मैं किसी का दरवाज़ा बंद कर रहा हूँ तो वो तो मैं बिल्कुल, मुझे इस्तेमाल नहीं करना चाहिए. तो आप ये पिटिशन लाते, सपोज मैं चीफ जस्टिस होता, मैं इसको लगाते ही नहीं, तो हम ये बेकेस ही नहीं सुनते कभी. 10 साल पड़ा रहता, मैं मजबूत रहता चीफ जस्टिस के तौर पे. आप खुश थे उस बात से. तो बराए करम आप ये जो बार बार बात करते हैं ना, मेरी मर्जी मेरी नहीं है. जब मैं चीफ जस्टिस हूँ تو برائے کرم ہم وکیلوں کو بہت ہی قدر کرتے ہیں، مگر میرا کا لفظ نہ استعمال کیجیے. انگریزی میں کہتے ہیں می مائی سیلف اینڈ آئی آر دا 3 موسٹ یوز لیس ورڈز ان دا انگلش لینگویج. اس کا میں اردو میں ترجمہ نہیں کر سکتا ہوں، شاید آپ بہتر کر سکیں گے. برائے کرم آئین کا حوالے دے دیجئے کسی چیز کے متعلق کہ یہ آئین کے تصادم ہے، وہ آئین سے تصادم رکھتا ہے، یہ شک آئین سے تصادم. ابھی تک میں نے آپ سے وہ ایک لفظ نہیں سنا ہے اس پہ. شکریہ.
میں نے تو 3-4 جگہ کہہ دیا ہے کہ جہاں پہ 184(3) میں آپ اپیل کا رائٹ دے رہے ہیں تھرو دس آرڈینری لا، یہ ہو نہیں سکتا بیکاز دس کین اونلی بی ڈن بائی اے کانسٹیٹیوشنل
میں
امینڈمنٹ.
لفظ لکھا ہے اگریو پرسن. ٹھیک ہے. اب دیکھیے، اب ایک مفہوم تو یہ نکلتا ہے 184(3) کا کہ آپ ایسے معاملوں میں نہ الجھائیں اپنے آپ کو جو انفرادی نوعیت کے ہوں.
اگریڈ سر.
ذرا اگریڈ آپ سے اگری کریں یا نہ کریں، میں ذرا بات کر لوں. انفرادی نوعیت کی، اگر ہم انفرادی نوعیت کے کیسز فیصلہ کرنے لگیں تو وہ بیچارہ کہاں جائے گا؟ میں آپ کو مثال دے دیتا ہوں. ریکوڈی کا کیس چلا، دونوں کیس فیصلہ ہو گئے تو میں اس پہ بات کر سکتا ہوں. ریکوڈی کا کیس آ گیا، ٹھیک ہے. سپریم کورٹ نے 184(3) میں اگریمنٹ اڑا دیا. ملک کو، سپریم کورٹ کو نہیں، ملک کو $6.5 بلین کی ڈز لگی. ہم نے کون سا جورسڈکشن استعمال کیا؟ ہم نے ایڈوائزری جورسڈکشن استعمال کیا. اگر ہمارے پاس یہ جورسڈکشن ہوتا، میں نہیں کہہ رہا ہوں فیصلے اچھے تھے برے تھے، میں صرف اس پہ تبصرہ کر رہا ہوں، ٹھیک ہے. اگر ہمارے پاس جورسڈکشن ہوتا، ہم وہ جورسڈکشن استعمال کر رہے تھے. اب ہم نے ایڈوائزری جورسڈکشن سے معاملوں کو ٹھیک سمت رکھنے کی کوشش کی، ٹھیک ہے. آپ کہتے ہیں نہیں، ملک کو $6.5 بلین کی ڈز لگ جائے تو لگ جائے. انڈیپینڈنس آپ کی چیف جسٹس کی ساخت پہ کمی نہ آئے. یہ ایسے پاورز اپنے لیے تو نہیں چاہیے. میں اب وضاحت کر دوں، اگر آپ مجھے دینا چاہتے ہیں میں پھر بھی نہیں لینا پسند فرماؤں گا. آپ پلیز آئین کے تقاضے پورے کریں.
میں یہ میرا مقصد ہی نہیں ہے. آپ میں یہ آنسر کر دوں گا. میں یہ بالکل 184(3) کے جو کنڈیشنز ہیں وہ بھی میں آپ کے سامنے پوری کر دوں گا. اور وہ 2 کنڈیشنز ہیں پبلک امپورٹنس اینڈ فنڈامنٹل رائٹس. فنڈامنٹل رائٹس میں رائٹلی سائڈ سے independence of the judiciary is a fundamental right.
Can we go back to my question before you get into the merits of all these arguments? The question is again, if the law is to be sustained, what is the effect of Section 5, which gives a right of appeal, given that a full bench is going to hear the case and decide the matter? Then that full right of appeal is no longer there. It's redundant. It doesn't exist. So what is you have read the law now. اس کے اوپر آپ بتا دیں کہ
اور اس میں اسی کے ساتھ ایک سوال، خواجہ صاحب ادھر ہوں جی، ذرا 5 منٹ لگتے ہیں آپ مجھے دیکھتے ہیں.
نہیں سر، آپ
میں آپ سے صرف اسی سوال کا آگے چلتے ہیں کہ اس 4 میں لکھا ہے کہ 5 یا 5 سے زیادہ ججز کا بینچ بنا سکتے ہیں نا، تو فل کورٹ بھی بنا سکتے ہیں نا 4 میں. تو پھر 4 کو 5 کو اکٹھا پڑھیں تو اگر فل کورٹ بن گیا تو پھر اس کیس میں اپیل نہیں ہوگی. بس آپ اس کا بھی جواب دیجیے.
تو اس میں ایڈ آن کوشچن ہوگا کہ ڈز دیٹ ناٹ مین کہ ہم پھر ونس اگین خود ہی ڈیسائیڈ کر لیں گے جہاں ہم نہیں چاہیں گے کہ اپیل کوئی ہو کسی کیس کا تو فل بینچ بٹھا دیں گے. ڈز دیٹ اگین ناٹ اماؤنٹ ٹو اے پاور بینگ ایکسرسائزڈ بائی دا کورٹ اٹ سیلف؟ So the control factor that there is a right of appeal, which is a substantive right, how can we just say that that right cannot be exercised? It's a substantive right.
ایک question اور بھی اسی میں ایڈ کر لیتے ہیں اس طرف. فیض صاحب, to your right. ہم یہ بھی دیکھیں گے through this petition there is an order of this court. The act has been suspended. Whether in presence of that order full court can be constituted or not. یہ بھی ذرا دیکھیں. Court can be constituted or not.
آپ جواب دینا پسند فرمائیں گے یا ہم shall we proceed to the next council؟ پھر آپ سوچ کر کے آپ جواب دے دیجئے. ٹھیک ہے,
میں نے تو پروپوزیشن کر دی.
ٹھیک ہے, آپ آئیے. کون آرگیو کرے گا نیکسٹ؟ اچھا, آپ اپنا کس پٹیشن میں ذرا بتا دیں.
تینوں میں خواجہ صاحب کے ساتھ.
جی,
تینوں میں خواجہ صاحب کے ساتھ.
To right of 2 counsel is not allowed unless you are separate petitioners.
7 میں 6 ہم بیٹھے ہیں, ایک میں آپ 7 میں میری حاضری ہو گئی.
جی چلیے بتائیے.
Followed the proposition is, the proposition requires to be requested. There is, the fundamental question is whether the parliament has the jurisdiction and the power to promulgate this act or not.
No, that is not the fundamental question, with utmost respect. The primary question is whether 184.3 can be invoked. First, you overcome that hurdle, then you argue that. So you have filed a petition not in the normal jurisdiction. You have come in original jurisdiction of the Supreme Court, which is not a right. You have to comply with certain provisions of the Constitution.
Well, Lord, there are number of judgments.
I'm not interested in judgments. I'm talking about arguments.
I am making submission, my Lord. The Supreme Court at various point of time has held that any clog on the powers of the Supreme Court or the functioning of the Supreme Court is constitutes.
मैं फिर आपको बात समझाया नहीं सका. For instance, let's take income tax ordinance. ठीक है, उसको आप बिल्कुल स्ट्राइक डाउन कर सकते हैं और उसको चैलेंज भी कर सकते हैं आर्टिकल 199 में हाई कोर्ट के पास. ठीक है, हम क्यों जुरिसडिक्शन एक्सरसाइज करें 184.3 की? ये शायद आपके हिसाब से ये कानून दुनिया का बदतरीन कानून हो सकता है. ठीक है, मगर बुनियादी सवाल 184 का दरवाजा जब आप खोलेंगे तो उसमें दो चीजें हैं. मैटर ऑफ पब्लिक इंपॉर्टेंस, सीकिंग इन्फोर्समेंट ऑफ फंडामेंटल राइट्स. बता दीजिए कि चलिए पहले वालों को जरा ग्रे एरिया, दूसरे वाले में तो आप बता सकते हैं ना फंडामेंटल राइट. पार्लियामेंट अच्छा कानून बनाए, बुरा कानून बनाए, ये हम पार्लियामेंट्री डिबेट इधर नहीं करेंगे. आप 184.3 में हो सकता है कल को हाई कोर्ट में आप ये पिटिशन लगाते, वो अलाउ कर देते आपकी पिटिशन, फिर आप हमारे पास एपेलेट जुरिसडिक्शन में आते, हमारे हाथ बहुत खुले होते. अब आपने बहुत नैरो इंतखाब किया है, 184.3 का इंतखाब किया है.
My Lord, there are number of judgments of the Supreme Court.
जजमेंट्स हावी नहीं होते हैं आइन पे. अच्छा, 189 पढ़ लें जरा. ये आप लोगों के जरा गलत फहमी क्यों है? 189, एक सेकंड 189 पढ़ लेते हैं साथ में. जरा पढ़िए 189. जी.
सुप्रीम कोर्ट प्राप्त फायज़ ईसा का इल्जाम लगा पुलवामा ड्रामा